against their 401k. You know, I mean, they've exhausted every possible area of borrowing, and they're at the end of the line. And you know, a lot of times they come in, they're embarrassed, and you know, and they really have gotten to the and you know, frankly, if they were able to, they probably would have kept doing it, but they just ran out of options. No more balance transfers along the way. They've maxed out their loans on the 401. You know, their mom won't lend them money anymore.
Right.
You know, and they come to us, and they're at the end of the line.
Now, you said in another program that you advise that the mortgage payment be the first payment. So if we take this scenario that you shared with us, and we have credit card debt, and we have balance transfers, and there are boat payments, and there's a mortgage to be paid, do you also agree, pay the mortgage first?
It depends. It depends. I mean, the good news is that in a Chapter 7, an individual, if they qualify, and we can get into that a little later, could walk away from that debt and get a fresh start. I mean, if they are just in over their head and they can't, there's just no way out, they can actually just walk away from it. And if they're going to do that, it doesn't make sense to pay the mortgage because you're throwing the money away. You could generally stay in the house for a short period of time while the foreclosure process is going on, and so you get the benefit of kind of living there, and you can get prepared to make a move, especially if you have a family. So the good news is that you know, you could liquidate all that debt and get a fresh start, assuming that you qualify. You would pay the mortgage, though, if you were considering a Chapter 13. You would try to work something out with the mortgage company, and you could build in payments. It's a bankruptcy plan that you would come up with, and you would pay into the plan to the trustee to distribute to creditors a certain amount of money every month to satisfy the arrears on your mortgage while you're paying the regular mortgage payment.
So just to remind the audience, that means that arrears is back monies owed.
Yes.
Chapter 13, we're going to be paying
back a portion
maybe
of the debt.
10, 20, 30% of the debt
Now,
over a period of time.
That's only the consumer debt. In a foreclosure, you're going to pay it all back.
Okay.
You know, so you're going to pay whatever the bank, usually the bank's attorney's involved at this point, and they'll send you a letter, and the letter will say you need X number of dollars to bring this mortgage current. And that's the number that you plug into the plan. And that plan would be paid out. You'd pay that back over the course of 3 or 5 years, depending on the type of plan that you enter into.
Right. Well, let me ask you about this, because I know that you and myself all went to law school, and it cost me a lot of money in loans. And
you're stuck with them.
I am stuck with them.
They're not dischargeable.
They're not dischargeable. I was hoping to get a little advice here.
They're not. You know, especially under the new law, there used to be, you had some ability under the old law to discharge. Years ago, if it wasn't a...
But let me interrupt you one second. We're talking about loans in general, not just law school student loans, but
student loans.
All student loans in general. So it doesn't matter if you went to college for basket weaving. We're still talking about federally funded student loans, not just law school loans.
Just to take a step back, when you're looking at bankruptcy, you have to look at the type of debt that you have, because there's certain debt that isn't dischargeable. There's certain, guess what, taxes that aren't dischargeable. In fact, most taxes aren't dischargeable. A big surprise there, right? Student loans that were government-backed years ago were just absolutely not dischargeable, but there were certain student loans that were privately held that were dischargeable under certain circumstances. And there were some little rules that said, you know, if you paid your student loans for 7 years, consistent payments, there were certain rules that permitted you to discharge them in bankruptcy. And that's not to say that you can't contact a lot of these companies. Sallie Mae is like one of the more popular ones. A lot of times they'll renegotiate in the event of a hardship. And right now under the new law, it has to be a hardship. So if you can show that there's a substantial hardship, you might be able to discharge a student loan. Have you seen that, Susan?
I've seen a few. I haven't had as many bankruptcies, obviously, as you have, Chris, but I'm seeing that, yes, more and more, and it is very difficult to discharge a loan. Taxes are almost impossible. The best you might be able to do is alleviate some interest and penalties, but the principal balance of the tax I have never seen discharged.
Principal balance and school loans, very hard as well.
Very difficult. Also, anything related to a family law court order. Support, you know, if you have a support obligation, you can't discharge that. There's certain issues that arise out of a property settlement agreement or a judgment of divorce. If you have an obligation to pay something pursuant to that, a lot of times, most of the time, those obligations are not dischargeable in bankruptcy. So you have those types, that class of debt. You also have debt related to like motor vehicle fines and surcharges. Very
And you can
diff-
make those go away?
very
Wow.
difficult to discharge. You know, anything that has to do with like fraud, anything that's penal in nature, and again, there's a lot of rules that apply to this, and there's circumstances where yes, sometimes they are dischargeable, but for the most part, if there's a penalty, you're paying a fine. If you've been found guilty of fraud in some type of case in a civil case, a lot of times those types of debts aren't dischargeable. Another class of debt that's not dischargeable is debt that is incurred by virtue of fraud. You know, if you go and you fill out a credit card application and you say you make $100,000 when you only make 60, and they find that out and you file a bankruptcy petition and they look at that application, they compare it to the tax returns that they review, and they see, whoa, this guy, he lied. You know, you probably wouldn't be able to discharge that debt. It's fraud. So, you know, in going through the process, I generally will tell people, look, you know, you can't discharge everything, but what we'll do is we'll look at all of the debt, we'll examine all the debt, and we'll separate it. We have secured debt, which is debt relating to a mortgage on a house or a lien on an automobile, or maybe a loan from a pension fund. They're kind of in a separate class now. And then you have consumer debt, which is credit cards, medical bills, any other debt, the loan you took from your mother-in-law, you know, that kind of thing. Those are generally consumer. The bankruptcy law is designed really not to give anybody priority, but generally people who have a security interest in real estate or a car, they're given a priority because they have a lien on that. It's not something that there's nothing you can really do to get out of that. So the trustee would look at that and they would say, well, he's got a car worth $20,000 and he owes $20,000. They're not going to be interested in liquidating that.
Let me just take a step back, and I'll throw this to you, actually. What's a trustee?
The trustee is the person that's appointed by the court, normally an attorney, who sort of oversees what they call the bankruptcy estate. The bankruptcy estate is all the debt that is claimed under a bankruptcy petition, and therefore, lack of a better term, the financial person who assesses an individual or a couple's bankruptcy petition. And they look at the assets, they look at the debt. If it's a reorganization, they're the ones who are going to be pretty much collecting the payment that's going to be dispersed under reorganization plan. And they're the ones who will actually have them come in what's called a meeting of the creditors, and the trustee will sit down with each debtor that's seeking a bankruptcy filing and go through their petition. This is how much income you make, this is what you have on debt. They may have questions as to what is this expense related to, why are you paying X number of dollars for this, I see you have debt that came from this, can you explain the circumstances? They want to see that they're legitimate debt, that you're not trying to commit a fraud on the bankruptcy court. And they sit down, they sort of interview each individual debtor at a meeting of creditors to verify the information that was put in the petition, and then sort of oversee that particular matter. And I guess the easiest way is they're the middleman between the bankruptcy the claimant and the judge.
So what would it mean to perpetrate a fraud on a bankruptcy court? I don't want to get too legalistic here, but if
Ken,
you have some...
Before we get into that, I just want to follow up, very important. The trustee has an obligation to the creditors as well. I mean, just to follow up, their job really is to find money.
To find money. So this goes right into the fraud thing. Sure.
Yeah, so it's important. So it's interesting you bring that up because the trustee, they're going to ask you questions. Like, for example, if you sold a piece of real estate right before you filed bankruptcy, you're not allowed to do that. You can't just liquidate all your assets, send the money offshore, file bankruptcy, get rid of your debt. You can't do that.
How about a trip to Vegas?
No trips to Vegas.
No trip to Vegas?
You know, Susan is right. I mean, the trustee is sort of the middleman. The trustee's job is, let's find money to satisfy these creditors, and if they don't find money, they'll generally send a report back to the bankruptcy court and say they're eligible for a discharge. That means that all the debt is discharged. Depending, I mean, if it's a 7, if it's a 13, you have to go through a confirmation hearing to get your plan, your Chapter 13 plan confirmed.
So let's explore this just a little bit in depth. You're saying that if someone is going to declare bankruptcy,
yes,
they go before the trustee, and they have to be open and forth with all their information.
Yes.
And then the trustee, who has an obligation to the creditors as well, is going to try and get money?
He's going to. Like, if, for example, say Susan is contemplating bankruptcy, but she's involved in a personal injury action, and she's about to get $100,000 because she was in a car accident and she herniated a disc. The bankruptcy trustee has a right to actually take a portion of that money. In a personal injury action now,